You're joining us in our legal FAQs category, powered by our legal partner Anthony Gold, and I'm joined by Rob from the housing team at Anthony Gold, and we're going to talk a little bit about the actual process of serving notice on a tenant. And Rob, most landlords tend to go down the Section 21 route. Why is that the most popular route?
You find the Section 21 route is probably the most preferred route for a landlord to seek possession because it's a non-fault route for possession, which means that they don't have to prove the tenant is in rent arrears. All they have to do is serve a notice either at the end of the fixed term or within the period of tenancy, and they can issue proceedings and seek to have the tenant evicted from the property.
So it might just be that they want their property back because they're thinking of selling it, or something of that nature. Yes, there's
various different reasons why they may require the property back, but it's obviously dependent on the landlord and on what they're seeking to achieve.
Quite. So the first step of getting a property back is to serve the Section 21 notice, and this has to be done in a specific manner, doesn't it?
Yes, so for tenancies, or previously tenancies that were entered into before the 1st of October 2015, Section 21 notice had to be served. It had to give 2 months notice for the tenant to vacate. If the tenant failed to vacate within those 2 months, then possession proceedings can be issued at court, and then obviously follow the procedure through court. And if the tenant still failed to vacate the property at the end of the court proceedings, then you would make an application for a transfer, for a warrant of possession, and have a bailiff to remove them from the property. After the 1st of October 2015, this is where things get a bit more complicated under the Deregulation Act, and there are many more requirements which the landlord has to comply with before serving the Section 21 notice. These include the previous requirements of the tenancy deposit protection, and also whether they have the relevant HMO licence. But after the changes under the Deregulation Act, a Section 21 notice can't be served within the first 4 months of the tenancy. The Section 21 notice has to be in the prescribed form. Also, they can't serve a valid Section 21 notice if they've failed to provide the tenant with a copy of the Energy Performance Certificate or a Gas Safety Certificate, or failed to provide the tenant with a copy of the government's How to Rent Guide at the beginning of the tenancy. Also, there are further provisions under the Deregulation Act relating to retaliatory eviction, which can also prevent a valid Section 21 notice being served. And these relate to complaints made by the tenant in writing about the condition of the property and whether the local authority have served the landlord with an improvement notice. So these are all going to add to the difficulty in serving Section 21 notices.
Very good. So let's assume that the landlord has served a valid Section 21 notice. The tenant hasn't moved out within the 2-month period. So stage 2 is the court hearing. I've attended one recently myself. It was actually quite short. I had a legal representative there, the letting agent attended, the tenant attended, and it lasted about 10 minutes. So it's actually nothing to be scared of, is it?
Yeah. Possession proceedings are usually listed for around 5 to 10 minutes. They're not very long. So yes, you once you've issued the court papers, you will be given a court hearing date. You'll attend court. You can either represent yourself or seek legal representation. Representations will be made to the judge. He will make a decision on whether an order should be made. If that is the case, then the tenant will be given a specific time period to vacate the property. If they fail to vacate within that time period, then you will have to make an application for a bailiff to remove them from the property.
Which is the third stage.
Which is the third stage, yeah.
And hopefully they will have moved out by then. But I think the main thing about the court hearing is to make sure you've got all your paperwork and all your documentary evidence to support whatever it is that you're saying. Yeah,
particularly after the changes under the Deregulation Act and any tenancy after the 1st of October, it will be obviously more difficult to issue proceedings, and they're very unlikely to succeed if you don't comply with all of the relevant procedures. And yes, any evidence will be supported by witness evidence. This can be done in the form of witness statements, etc.
So if we go to the third stage now, where the bailiff is called, does the landlord have to attend, or can they just wait to hear of the outcome?
Usually, I think it depends on preference. We do advise landlords to attend the property. and that's mainly because bailiffs won't wait around. That they will go if there's nobody at the property. But we do usually advise that landlords attend, and also attend with a locksmith, and they can change the locks on the property once the tenant has been removed.
So really, Rob, it's a very clear, straightforward 3-stage process that landlords should follow, and make sure that they do everything in the correct manner with the correct paperwork, and if in doubt, get some legal advice.
That's correct, yeah.
Yeah. Okay, well, thanks very much for joining us, and hope you've enjoyed this overview of how to serve notice correctly on a tenant and eventually remove them from your property if necessary.